Welcome to today's program titled Enforcement Risks for DEI Programs, What Government Contractors and Private Employers Need to Know, Part 1 of our Shifting Diversity, Equity, and Inclusion Landscape series. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE Attendance Verification Code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions that you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you so much, and welcome to everyone for joining us on this important topic today that we are going to be tackling. My name is Annette Timon. I'm a partner in our Labor and Employment Practice Group, where I chair our People Analytics group. As part of my regular practice, I work with a lot of other terrific attorneys that work with many employers on navigating diversity, equity, and inclusion issues, and in particular, with some of the recent executive orders that have come down, how those issues are shifting and navigating. Today, however, I am thrilled to be joined by a true cross-departmental view, because we've been getting so many questions around issues that may not necessarily fall squarely in the labor and employment practice area, but really have much larger tentacles, as we'll see as we navigate the issues. So today, you're going to hear from Teddy Arnold, who is a partner in our litigation and government contracts group out of our DC office. Ellen Murphy and Chris Robertson are also partners. They are joining us, do a lot of litigation work on securities and financial matters, and in particular, they have deep expertise on navigating government investigations and those issues. So today, we're going to go ahead and talk high level. On our next slide, you'll see kind of the overview. So very quickly, we're going to talk about some of the key, actually the key executive order 14173, that has been driving some of the more recent shifts on DEI issues. And we're going to then talk about False Claims Act implications, what targeted organizations might expect from agency investigations, and give you some strategic responses and next steps as takeaways for you to consider. On the next slide, I'll just briefly talk about that executive order just to set the stage. Shortly after Executive Order 14173 was implemented, we had a full, and there was actually a series of another 4 or so executive orders that we laid out in a prior webinar, so feel free to contact us if you'd like a recording on those. But so we're talking at a pretty high level here on the next slide. We'll talk about, ending illegal discrimination and restoring merit-based opportunity. That was the title of Executive Order 14173. And that specific executive order has a lot of implications and sort of a wide breadth in terms of how employers, including federal contractors and agencies, are being affected by the shifting landscape, and in particular on eliminating illegal DEI practices. Some of the specific requirements were directed at agencies and how they operate and how they function. But it's important, and so we sort of rely on those and look to those to see what the specific issues are that the current administration, how they would view issues. They're not necessarily binding on private employers or federal contractors, but we look to just get a sense of where the agency is on some of those issues. The last two bullets on this particular slide, though, revoking Executive Order 11246, which ended affirmative action obligations for federal contractors, and directing federal agencies to take action against DEI discrimination throughout the private industry, is an issue that has been felt more directly by private employers as well as federal contractors. And there's two new certification requirements that we'll talk about as well, that also implicate federal contractors in particular. On the next slide, we'll just give you that kind of higher level view on Section 4 of Executive Order 14173. And Section 4 was really a specific, had a specific view on encouraging the private sector to end illegal DEI discrimination and preferences. And I note the word illegal because it's not, it's a specific type of practice or initiative that, frankly, as of right now, is undefined. So we don't really know what the current administration views as illegal DEI, but it's not all diversity, equity, and inclusion programs. It's certain ones. It also directs federal agencies to take appropriate action to advance the policies of the agency with regard to the federal sector. It was directing the Attorney General and other agency heads to provide recommendations for enforcing federal anti-civil rights laws. And in addition, the Attorney General is directed within 120 days, and that's going to be at around May 21st, that they are to create a strategic enforcement plan that identifies certain sectors of concern within their jurisdiction, really identifies the most egregious practitioners, outlines some deterrent steps. And so all of that has created some significant concerns for employers as well as specifically federal contractors in terms of what does that all mean, what are the implications, and how do I navigate them going forward. As we turn to the next slide, we'll see that, so Executive Order 14173 came out on January 21st. And shortly thereafter, just about a month later, almost on the dot, there was a lawsuit that was filed to enjoin the certain provisions. So not all of the provisions, but certain provisions. There was a lawsuit that was seeking to stop the programs. And the federal court of the District Court of Maryland did issue a preliminary injunction temporarily prohibiting the enforcement of certain of the provisions. It has other implications for other executive orders, but for purposes of our discussion today and setting up the stage for what Teddy, Chris, and Ellen are going to talk about more specifically, is that the certification provision that Teddy's going to go in more detail about, that is currently been enjoined. So departments, agencies are currently prohibited from including those certification requirements in their federal contracts or federal grants. And then the enforcement threat provision has also been enjoined. That preliminary injunction applies to not just the plaintiffs that brought the lawsuit, but it was a nationwide preliminary injunction. Interestingly, on the next slide, we'll see what the preliminary injunction does not do, okay? It does not stop any investigations or lawsuits that are currently in place under Title VII. It doesn't prevent private plaintiffs from bringing their own claims, their own actions based on what they perceive to be illegal DEI program, nor does it prevent the Department of Justice or any other agency or state's attorney generals from issuing letters, doing their own investigations, or filing their own lawsuits based on the employer DEI practices. The court did decline to enjoin the Attorney General from preparing the report that I mentioned would be coming up on May 21st, and they also declined to enjoin the Attorney General from engaging in their own investigation. It's only the enforcement or bringing actual civil rights investigations, lawsuits on that basis. The court primarily identified two specific issues, so due process and First Amendment issues. In their decision, there was in particular, a concern that the term illegal DEI had not been defined. So employers really don't have a good sense of what that actually means and how they should navigate that. On the next slide, we'll see there's already been additional action. So the Department of Justice has already filed its notice of appeal. Opening briefs are due at the beginning of April, on April 8th, actually. And the Department of Justice has requested a stay pending that appeal. In their opening brief, they did request a ruling by March 14th. We'll see if this is all pending at the Fourth Circuit. That's where the case is being briefed. Separate and apart from that, so even though there was this preliminary injunction, there was also additional activity at the district court level because we were seeing some agencies that did continue to include the certification provisions. And there was some back and forth and some briefing that went at the district court that requested a motion for clarification in terms of the scope of the preliminary injunction. The Department of Justice took the position that only those agencies that had been specifically identified as defendants in the complaint, those were the only ones that were subject to the preliminary injunction. Plaintiffs filed a motion for clarification just a few days ago. The ruling came out that clarified that all agencies, all federal executive agencies, were part of the preliminary injunction. So that is the current state of affairs in terms of the executive order and where we stand currently. And with that, I'm going to turn it over to Teddy, who's going to walk us through some of the False Claims Act implications, as well as other implications that employers and federal contractors in particular have on these issues.
All right, thanks very much, Annette. So EO 14173 has certainly elevated the False Claims Act as an enforcement tool. So I'm going to talk a little bit about the background of the statute. It's important to have that background, when it applies, when is it triggered, how it functions in the context of the executive orders, as it's a fairly complicated law with a broad reach. So I'll just give you a little bit of background, then I'll dive into some of the more specifics as it intersects with the executive order. So even prior to the executive order, the Civil False Claims Act has been for a long time the government's primary tool to combat procurement fraud. It's a very old law. It dates back to the 1860s in the Civil War when it was enacted. It's predominantly used in the healthcare space to prosecute healthcare fraud. The vast majority of the dollar recoveries every year are from healthcare companies arising out of claims submitted to Medicare and Medicaid. And sort of a distant second place in terms of dollar recovery are traditional government procurement contractors. Those are providing goods and services to the government, particularly in the defense area. And so the statute bisects, or it bifurcates, I should say. It has a civil and a criminal section in the U.S. Code. It's in Title 18 of the U.S. Code. There's a criminal law that is not as widely used. The civil component in Title 31 is very widely used by the DOJ and by the QTAM relators that Chris and Ellen are going to speak to a little bit more. But essentially, what is it? It's a statute that creates liability for those who knowingly submit false claims to the government. And so that's a can of worms. I'll try to unpack a little bit of that. So what's a claim? A claim is a request for money, otherwise known as an invoice, someone who wants to get paid. All liability arises out of an invoice. So if you're not invoicing the government directly or indirectly, there can be no imposition of the False Claims Act. There could be liability under other laws for different types of misconduct, but the FCA is premised on the submission of a false claim. In the context of labor and employment disputes, you may be familiar with the statute with a certain provision in the statute known as the anti-retaliation provision. That protects employees who report or take action to stop fraudulent activity against the government from being retaliated against by their employer. And so this provision essentially allows individuals to blow the whistle on the government for fraud without fear of job repercussions. I mention this because it's a fairly unique part of the law because it allows these claims to be filed separately from either a qui tam action or a DOJ enforcement action. Those require a very specific process you have to follow, which I'll touch on. But you can basically, as a plaintiff in a labor employment matter, you can essentially, as one of your causes of action, you can file a claim for anti-retaliation under the False Claims Act. So for the main section of the False Claims Act, you need a claim. As I said, the claim has to be false. That sounds simple, but it's actually quite difficult because there's two types of falsity. There's factual and legal falsity. Factual falsity is much simpler. You essentially submit an invoice that has some kind of incorrect description of the goods provided, or you're asking to be paid for goods you never provided. Pretty straightforward. Legal falsity, which intersects with the executive orders, occurs where you're actually providing goods to the government and you're invoicing for those goods. And there's essentially nothing facially wrong with your invoice, except that you are failing to comply with some ancillary requirement in a statute, a regulation, or under your contract. And so the FCA liability there is not tied to a defect in the invoice, but it's premised on a legal violation, such as a federal anti-discrimination law, for instance, as we're talking about here. And so within that, guys, there's different types of legally false claims. There's either express false certifications or implied false certifications. The point is you either can expressly certify that you're in compliance with the law, or you can implicitly certify compliance with the law. And it gets very complicated from there. But when you're dealing with the legally false claim, one critical component of the statute is that you have to show, the government has to show materiality, as it's known. That word is used in the executive order. Materiality is defined as having the natural tendency to influence the payment or receipt of money or property. And so essentially what it means is the government is saying, I am paying your invoice because it is a material provision of your contract that you are in compliance with XYZ law, whatever that materiality standard is. So it's a very strict standard, as said by the Supreme Court. Not every law and regulation is material to the government's decision to pay your invoice. And so I'll touch on that in a sec when we talk about risk under the EO. The last component is there has to be knowledge, so otherwise known as scienter, and that encompasses three mental states: either actual knowledge or deliberate ignorance or reckless disregard of the truth or falsity of your claim. And so a lot of people refer to the False Claims Act as a negligence statute because it doesn't require specific intent to defraud. You may just have been negligent in failing to ascertain the factual or legal falsity of your invoice that you are submitting to the government. And if you meet the standard of reckless disregard, you may trigger liability. Damages, there's statutory penalties that attach to every invoice, every claim. There's also treble damages. So whatever the damages the government can establish times 3, that's the amount of the damages you would be liable for. So that is the big sort of scary aspect of the statute, is that the amounts can stack up very quickly. It has a qui tam provision, allows whistleblowers to bring suit in the name of the government. And Ellen and Chris will go into this in more detail. The government can intervene in the suit. The relator can share in the recovery of the settlement or the judgment that incentivizes someone to blow the whistle in the first place. Government can move to dismiss, and there's a number of threshold defenses you can deploy after that. You actually go to the next slide, and I think we should have advanced one more. You can advance past. Oh, here, no, sorry, stay on this slide. So executive order, the executive order we're talking about, 14173, requires agencies to include in every federal contract and grant 2 prongs. One is a requirement that their compliance in all respects of the applicable federal anti-discrimination laws is material. There's that term of art, material, to the government's decision to pay for purposes of the False Claims Act. That's one. And then there's a certification requirement that you are not operating what we'll call an illegal DEI program, something that violates federal anti-discrimination law. There's also the instruction to prepare a strategic enforcement plan, but I will not talk about that. I'll talk about prong A and prong B. So what qualifies as an illegal DEI program? We're not going to cover that today in any depth. I think that's for a future webinar. But essentially, the big point is it's not defined what the administration believes may be illegal. And it's unclear whether we're going to get additional guidance clarifying that. But importantly, the executive order does not change the law on DEI programs. If a DEI program was lawful under federal anti-discrimination law before the executive order, it would still presumably remain lawful afterwards. But again, we'll see what kind of guidance we get. The executive order certainly increases the risk profile for DEI programs, whether lawful or unlawful. And where is that line? It's thought of that the administration is going to take a broad view of what DEI programs it believes to be illegal. So you go to the next slide. How is the executive order? How are these requirements implemented? Note that they must be implemented through to contractors via a contract modification. So until your contract is modified, there's no compliance obligation under your contract, although FCA liability may still remain, which I'll touch on in a minute. But the way the contract compliance would come about would typically be done via agency rulemaking under the FAR. We saw this during COVID, and it's presumed here that a new contract clause will be promulgated by the FAR Council, that agencies will then take that contract clause, which reflects something along the lines of what's in prong A and prong B, and it will modify your contract via a bilateral modification, one that you will have to sign off on to make it binding on the contractor. That's the normal process. That usually takes months, although we have seen situations where the government acts quickly to implement new contract clauses, but there's been no action on that front as of yet. Agencies, there's the certification requirement. You can try and push back on it if there's an argument to be made that it's a cardinal change to the contract, or that it's unlawful, which we know is already being challenged via the injunction in the District of Maryland. And the risk is, to the extent the contractor does not agree to the bilateral modification that implements the new contract clause, the government does have the ability to terminate your contract for convenience or even for default if they think they can make the case for it. And so it does get a little murky there. Flow downs, there is no express flow down requirement that we've seen in the executive order. One would expect the certification language, when and if that gets flowed to your contract by the government, may have a flow down requirement to lower tier contractors. And I say that because the executive order has made clear that the government intends to hold contractors and subs responsible for violations of the executive order. So you will likely see that coming, but right now there's been no indication that there is a flow down requirement. The mandatory disclosure rule, I will touch on. Many contracts have this. If you're above $6 million, you would likely have this clause, which requires you to report certain instances where you have credible evidence of violations of particular laws. I mention this because one of those laws that triggers a mandatory disclosure is a violation of the Civil False Claims Act, which of course can be a very difficult determination given that it's a very complicated law. And typically that liability ultimately is determined by a judge or a jury. It's hard to make a self-disclosure where you think you violated the law. And you make those disclosures timely in writing to the contracting officer as the regulation states. So that's one thing that you'll have to be mindful of is, if and when you ever have any credible evidence, and that's an undefined term, that there is such a violation internal to the company. You go to the next slide. Okay, so risk of noncompliance, key TAM lawsuits, so whistleblowers, and then of course DOJ enforcement, and whether the breadth of the DOJ enforcement in this instance is sort of yet to be seen. There's a lot of chatter out there about it. We'll see how widely the DOJ decides to pursue these cases to enforce the executive order and the requirements therein. Key TAM risk obviously can be based on perceived unlawful DEI practices. That is sort of an ever-present risk for any company doing business with the government, whether it involves the executive order or not. Now that risk certainly is a little bit higher. The certification requirement that presumably will make its way into your contract, that materiality element will then all of a sudden be baked into your contract. So that could ostensibly make it easier for the government to prove that the submission of the false claim. However, the knowledge component of it, which I'll talk about later on when we get to best practices, is critical here. There has to be a knowing violation of the law. right? So even if you violate the law, and even if that violation is material, the government may not be able to establish knowledge, because if you're taking a good faith approach to compliance, you're trying to do your best to interpret the law and create compliance, across the board. It's going to be very difficult for anyone to establish that you did that recklessly, because reckless people don't take steps to try to comply. The False Claims Act is not designed to punish good faith mistakes or misinterpretations of legal requirements. So bolster your ethics and compliance program, that is going to be one of our best practices, which I will touch on when I circle back. But I think at this point, I'm going to turn it over to Ellen.
Thank you. Next slide, please. The executive order at issue obviously cannot and does not actually mandate any specific changes in the private sector from the perspective of companies that are not doing business with the federal government. Instead, what it is designed to do is essentially encourage private companies through the threat of investigations or potential actual litigation. Next slide, please. So in response to the executive order, on February 5th, the Attorney General Bondi issued a memo where she directed the DOJ Civil Rights Division and the Office of Legal Policy to jointly submit a report that was due on March 1st. Notably, there's been kind of no news reporting about what's contained in that report, at least as of yet. But that report was supposed to contain recommendations for enforcing federal civil rights laws and taking other appropriate measures to encourage the private sector to end, again, illegal discrimination and preferences based on illegal DEI policies. And the memo issued by Attorney General Bondi it indicated that the report should include many of the same things that that were included in the executive order. The key sectors of concern within the department's jurisdiction, the entities that they believe are the most egregious or discriminatory practitioners, a plan to deter the use of DEI and DEIA programs and principles. Notably, the Bondi's memo went a step further than the executive order did, in that the executive order never mentioned criminal investigations, but Bondi's memo does suggest that she would like to see proposals for criminal investigations for up to 9 potential and 9 potential civil compliance investigations, as well as additional potential civil litigation activities, regulatory actions, and guidance that can be issued. Next slide, please. And so what we've seen since then is a number of federal agencies kind of taking some sort of action. So on February 12th, we saw a letter from the chair of the FCC to one of the companies that it regulates, indicating that it was opening an investigation into their DEI practices. On February 14th, we saw the Dear Colleagues letter from the Department of Education, in which the DOE actually went through its interpretation of federal law related to the Civil Rights Act and DEI practices, warned educational institutions that it intended to vigorously enforce the law, and advised such institutions to assess their compliance with the law based on its interpretation that was included in the letter. And then as recently as Monday, we saw the announcement by the Department of Health and Human Services that it had opened 4 separate investigations into unnamed medical schools and hospitals under Title VI of the Civil Rights Act of 1964. Interestingly, the way that the announcement was structured, it suggests that perhaps this came from a whistleblower complaint, right? It says it was based on allegations and information that the Office of Civil Rights received regarding some of the programs that these medical schools and hospitals were, that they were operating certain programs that they thought might discriminate. So next slide, please. It begs the question of kind of what's the next step, and how do we think some of this will play out in the regulatory and government investigation space. So I think, as we've talked about a bit, how will an investigation start? it could start based on being identified through one of these agencies as being one of the 9. It could start through a whistleblower complaint. Notably, while both the executive order and the memo indicate that they want to identify 9 entities, companies, corporations, I would note it's not necessarily limited to 9. There's nothing to say that an agency can't identify more. And at least in respect to certain agencies, they often kind of do sweeps to determine who they're going to identify for further follow-up, so that they may send out correspondence to a large number of entities, which I think is what the Department of Education did, to say, hey, give us information about what your DEI policies and practices look like, and then we may whittle that down and only follow up with another, 5 or 6 or 9 or 10 of you. But the initial request may be much larger than just 9 entities. Chris, do you want to take the next point?
Sure. And so, whether it's because you've been identified by a regulator or whistleblower complaint, the question is, how am I going to know that something's happening? How am I going to know that I'm now under scrutiny or an investigation from a government agency? And, there's a couple different ways that occurs. And typically could be through a letter. We've seen a number of those just referenced on the prior slide that, the Department of Justice or a particular agency will send a letter asking for information or identifying that particular company as someone that they're open an investigation about. Obviously, a letter doesn't have any authority beyond, seeking cooperation and compliance. So it's not the other two. So the other two, one is a civil investigative demand, and that typically would come from an agency like the Federal Trade Commission, or might come from Health and Human Services. There's different agencies that operate their investigations through collecting information through a civil investigative demand. Again, that's an agency outreach under the authority given to that agency to investigate certain conduct over those to whom they regulate. There's no court required to authorize that or issue that. So that could simply be the DOJ or the White House directing an agency that they want, a particular entity investigated, and directing them to issue a civil investigative demand. And if you are in receipt of one, there are certain sort of procedural requirements that you may have to undertake pretty early on to try to define the scope of it and protect them. We haven't seen one yet, but we expect to see them. And then the question will be, how broad or how narrow is the scope? But typically they're pretty detailed, and you can learn a lot about the specific focus of the agency's investigation from the requests that are in there. And then the last is a subpoena, which could be an administrative subpoena or a actual civil or criminal court subpoena. And that typically will, have some judicial authority or, more authority behind it. Again, we expect, and I'll let Ellen jump in, that most of this will be civil at this point. But that does not take off the table that, something could come out and be criminal. So Ellen, you want to just speak to that a little bit?
Yeah, I mean, I think the expectation is certainly, given the executive order's focus on kind of the agencies and the request from the AG focused on civil stuff, that's what we're expecting. The inclusion of potential criminal investigations in the Bondi memo certainly raises the stakes, but I think the expectation would be we'll see civil stuff first, and then only when and if that doesn't go anywhere would they escalate it to a criminal matter, unless they see something truly egregious that would raise to the level of criminal conduct even before kind of the executive order. That's I think what the current expectation is, but some of it is we are certainly in a wait and see environment, unfortunately, at the moment.
Yeah, and you could see if it could start initially as civil, but then if there's recalcitrance or just an inability or unwillingness to respond, or they feel like things aren't moving quickly enough, they could rattle sort of criminal to try to get, more urgency and a reaction. We've seen that in other cases, not on this issue because this is all new, but in other areas where it may start as a sweep or it may start even as a targeted civil investigation. If there is some sense that the urgency is not there in responding, we can hear noises about elevating it to the criminal level. And that's always out there. And so obviously, cooperation is key, and really trying to get on the phone with the government sooner rather than later to sort of think about and discuss what they're really looking for. So, there's not a inadvertent failure to comply simply because you didn't really understand what they were looking for. I think, a lot of what we've seen in the letters and the memos and some of the materials flying around, and even to Teddy's point about, even defining DEI at some level, there's necessarily going to be some gray and confusion about exactly what they're looking for when these things start to hit. And I think it's important to try to scope that out and document it as early as possible, even if the answer is they don't even seem sure about what they're asking for. Document that as well, because as this hones in and as this narrows and as the government sort of figures out what they're even trying to look for, they'll get more precise. And what you don't want is a situation where in hindsight, it looks like you haven't been cooperative when really the issue was the government didn't really know what they were looking for. And so to that regard, what would they be looking for? And we have here on the slide that, it'll be correspondence, information will be related to DEI. That's obviously what they're going to be looking for in terms of the policies, the practices. If there are action items under a DEI program, what has been done, relative to executing on the DEI program. We expect that information, and you can expect broad requests, initiatives, preferences, mandates, policies, programs, and activities. But we think they're going to focus, once they have an understanding of what the program is, what has actually been done, in terms of action items executing under the program. That's where we expect they're going to be looking at, to say, not just do you have a program, but what have you actually done? Give me concrete examples of a decision that was made to do either X or Y because of DEI. What have you actually done under this program? And looking for information about that. And then, from there, we expect, again, sort of, broad requests, and then, a narrowing down to what the policy objective is underneath that. And that's what we expect. Now, I don't know if you want to echo that.
If I can just add one thing, I mean, if you see kind of the language on the slide that, they're asking for, one of the requests was asking for, an accounting of the DEI initiatives, preferences, mandates, policies, programs, and activities, including DEI activities that are operated under different labels. And so when you think about as an entity trying to collect documents, search for documents that might be responsive to that, the question then becomes, well, how do I find documents that are not under a DEI labeled activity, but that are responsive to this request? And I do think that this is where getting on the phone and talking to the regulator, talking to the government, talking to the investigator and saying, look, let's talk about search terms. Let's talk about what you're actually looking for, because the last thing I want to do is send you over a bunch of stuff that you don't want, and not send you what you are looking for. But this request, right, that may be operating under different labels, is not really conducive to me coming up with, a search term that I can use to kind of gather those documents for you. And then, so what does the process of a government investigation usually look like? It is usually a combination of investigative tools, the collection of documents, the interview of witnesses, representatives of the company. Sometimes it's retaining experts to kind of explain your programs and your policies behind them, and kind of the goals and how they operate. And then it's really conversations with the regulators and the government investigators to ensure that what they're looking for is getting met, that you're understanding what their claims are, that, you know, our response is appropriate to that and responsive to what their concerns are. And so I think it's really important to have that dialogue with the regulator, the DOJ, whether civil, criminal, whoever it is that's looking into this.
Yeah, and in doing that, you have that conversation, and they expect this. This is not coming up new. You have that conversation, and then without, you know, sort of trying to take a position, documenting what you've done, what you talked about, what you've agreed to. And then when you pull the documents together, you know, it's as we discussed, as we understood, here's what we've gotten. And we believe this responds to, for example, in a CID, they'll have what they call specifications. So in your typical CID, they may have 30 specifications. And in a typical government investigation, under a CID, you'll come to an agreement on, well, we'll get you responses to specifications 2 through 6. And we can delay getting 8 through 12 because that's going to take more time. But all of this should be documented. So again, you know, there's a clear understanding from the beginning, middle, and end of the process of what you're expected to do, what you're doing, what the documents are responsive to. And typically they'll do the documents first, although we have had recent cases, not again in this space, because this is all somewhat new, but recent investigations where we have gotten personnel on the phone pretty early on, not just the lawyers, to kind of explain the business, explain the program, explain sort of how things operate, so that that can help kind of define and narrow, ideally, the scope of what they're looking for. So, you know, it's going to be facts and circumstances, but there should not be an immediate reluctance necessarily, not just to get the lawyers on the phone, but potentially to get a company representative on the phone to really explain, you know, the nature of, in this case, the program, so that there's not a lot of spinning of wheels on information that either may not exist or is going to be of no real use to what they're looking to understand and get information about. So let's go to the next slide. So pretty quickly, excuse me, and are the types of investigations. We talked about this a little bit. So there's the agency investigations, and you've seen, we referenced some of the correspondence from those. Then in the Department of Justice, there's 2 branches. There's basically the civil branch of the Department of Justice and the criminal branch of the Department of Justice. And as we talked about, we think a large part of this will be done through the civil Department of Justice personnel and mechanisms, but it does not rule out the fact that a matter could be elevated to a criminal matter, depending on what they see as the potential severity of the issue, or again, a lack of cooperation. There could be other reasons. I don't know if you want to touch on that, Ellen.
No, I think we've covered this.
So let's jump to the next slide. Stay on schedule here. So I wanted to touch on whistleblower issues quickly, and then we'll talk about a little bit about sort of some action items. But they're under multiple federal statutes and programs. Employee whistleblowers can submit information and seek financial rewards. So it's not just I'm doing this out of the kindness of my heart. They actually can get money under multiple programs from the government. And so under these current executive orders, complaints about existing or continuing DEI programs could be filed by employees. And we don't know for sure, but earlier, one of the matters that Ellen referenced seems like it might have come from a whistleblower. And as Teddy talked about under the False Claims Act, where the whistleblower submits a claim under the False Claims Act, they can get up to a 30% bounty, basically, on any recovery by the government. But the matter is initially filed under seal. So the company wouldn't even know it's happening. What happens is it's filed under seal, and then the government has a period of time to review the matter and determine if they are going to intervene and actually take over the case as the plaintiff, or decline to intervene, at which point the whistleblower can still pursue the case, but they would do it in their name on behalf of the government. Both the SEC and the DOJ also have whistleblower programs which allow the recovery and benefit settlement. And all of these statutes, as Teddy mentioned, like the False Claims Act, have retaliation provisions that are independent of the ability to collect a bounty. So they could file something with the government takes the case over, charges ahead, and maybe ultimately get some kind of reward that they can share in. But independent of that, if they have been retaliated against, each of these statutes has an independent anti-retaliation provision where they can get separate employment-based damages or compensation that sits outside of whatever they would recover as a bounty. So an employee complaining about any of these existing DEI program, could claim, in addition to filing something with the government, also protected status. So that's why, and we'll go to the next slide. And one more. So there's strategic responses and next steps. I think one of the really important things here, to the extent that we're talking about these whistleblower issues, is companies should review their process for evaluating and responding to hotline or internal complaints to quickly identify and address complaints about discrimination or retaliation. These would normally be something that would be kind of at the HR level. They would be handled, it might be an individual saying, I've been discriminated against. But given this executive order, given this focus on DEI and this sort of redefining of what discrimination is, that could implicate broader corporate exposure. And so, I think a significant takeaway here is if those issues come in, they may need to be elevated more quickly and to a broader audience than they might have been. And so taking a look at your whistleblower, sort of not just the policy and the anti-retaliation policy, but also how those complaints are handled and who has visibility to them, will be something to look at. And Annette, did you want to touch on the DEI assessment?
Sure, I'm happy to. We have been doing an incredible number of assessments, and it really is taking apart and unpacking each and every program separately, and we're looking at all things, including how it's described, the specific, if anything's exclusionary on the basis of race or gender, looking at cases that have been filed to help employers navigate the specific issues. And so I would encourage you, if you haven't done that, to reach out to your mostly employment counsel on those issues, but we're even looking at things like supplier diversity and investments and things like that. Just to do that deep review that Teddy mentioned, that you're assessing and you're reviewing and you're doing what you can to ensure you have compliance with the laws, and we're continuing to monitor what might be coming from the agencies, even though we fully recognize that we're in a world where it's not absolutely defined what is considered illegal DEI, but looking at cases, looking at Title VII, Title VI, Section 1981, and other cases, we are helping employers assess their programs with a fresh set of eyes in light of the current administration's view and perspectives on these issues. So we encourage you to do that.
Yeah, and if I can just add, some practical tips, right? If you expect that you could potentially be one of the 9, or you expect that there is some chance you could receive a request for information, things that you can be doing from a practical perspective now. Again, I think it's important for it to be privileged because any steps that you take now without counsel, if in the event you do get a request or an investigation demand, all of that is ripe for the production. If it's covered by privilege, you'll have the ability down the line to decide what you want to share, or if you want to share, and kind of how much you want to share if it's covered by privilege. But things to be considering, any request we expect would cover some period of time. It would not just be your current policies. And so, thinking about documents and variations of policies and procedures that you've had in place over the last, let's say, 3 years, 5 years, identifying earlier versions of those documents, identifying the changes that have occurred over time and the reasoning for those changes, identifying the people in your organization that are going to be your go-to people to find out that information, potentially interviewing them now to kind of get their perspective on what the process and policies previously were versus what they are now and how they've changed and why. And to the extent that you are making changes in any of your DEI policies and practices, you want to be documenting those changes along with the reasoning for them. This, to the extent that you are part of an investigation, one of the things government investigators always look at is remediation, and what the company has done by itself before receiving requests from a government entity as to how they've improved their policies, their procedures, their practices. And I think that will go a long way in being able to talk to a government investigator or regulatory agency about, this was our policy, we now understand the interpretation is different. It is a little hard to do without the guidance on what the administration considers illegal DEI. But piecing it together as best we can and having a reasonable explanation for the changes that have been made and why they've been made will go a long way in showing that your company is looking to be on the right side of the law. The other thing I think it's really important to be able to do is assess any changes that you make to comply with federal law to ensure that it's still in compliance with state and local requirements. You've had a number of state AGs who issued multi-state guidance as recently as February of this year, who are certainly taking the position that many DEI initiatives remain totally legal, and that what the executive order is really aimed at, or should be aimed at, is unlawful preferences in hiring and promotion and things like that, but that there are lots of initiatives that are still wholly legal. And so you want to make sure that you're not on the wrong side of state law, but the right side of federal law. And that's going to be a tight rope to walk, I think, until we have more guidance from the federal government.
Should we go to the next slide? I can close this out. So I'm gonna pull the lens back a little bit. I'm gonna build off of what Chris and Ellen just said when we're now looking at kind of what can you do. I'm a big fan of compliance and ethics programs and best practices, getting out ahead to prevent and detect the issue and then mitigate and correct it where you need to. It's sort of, I always think of the Stoic principle of, focus on what you can control, right? There's a lot of noise out there, but if you stay calm, you take action to try and minimize risk. And remember, you can't eliminate risk. I was taught a long time ago, don't ever use the word eliminate because it's not really practical, but you can minimize your risk and you can build your case now and use it when you need it later on. But hopefully, obviously, you don't ever need it. So when we're talking about the False Claims Act, these are sort of the best practices that I would normally preach, regardless of the underlying issue. Here, we're talking about implementation of the executive order, but these are the measures you would take to buttress against a False Claims Act proceeding. So identify all contracts that are subject to the FCA. A lot of folks do commercial business as well as federal work. So not every contract requires claim submissions to the government, but you have contracts where you are invoicing the government. Make sure you segregate those, maintain them in a central location, update that list as necessary so you can track them. Complying with all applicable requirements. This is just identifying all the contract and grant requirements and all mandatory regulations and statutes. Obviously, only those that are material to the government's decision to pay would trigger a violation. But here, especially in light of the administration's heightened enforcement of enforcing federal anti-discrimination laws, that certainly is going to be argued by the government that those are material provisions of your contract. Strengthening internal controls and policies, who in your company is charged with the responsibility of ensuring compliance. I'll talk about that on the next slide. Reviewing the certification process, right? What are the requirements? And then who's going to be tasked with ensuring compliance with that certification? Who's signing, right? Individuals as well as companies can be prosecuted in a False Claims Act proceeding. And so if you're the person signing the certification, you want to make sure that person has appropriate knowledge, that they're trained, You don't want to task someone to certify who just isn't right for the job. You heard the others talk about this, documenting your intent to comply, particularly with ambiguous requirements. Good faith efforts to comply are going to go a long way to defeat the falsity of the claim, the accusation that you submitted a false claim. Developing training programs and relevant requirements and updating those, and then auditing and assessing those for weaknesses. What are the red flags in your industry? If you go to the next slide, I just like to preach, why do you invest in your ethics compliance programs? I realize that there's different sizes of companies that have different resources to put towards these programs, but there's a lot of reasons to do it. Number one, it's required by law in many instances. The mandatory disclosure rule that requires you to have internal controls in place for certain instances where the threshold is met. And of course, that can reduce penalties. You've heard the DOJ evaluation of corporate compliance programs document. That's how the DOJ views what did your program look like at the time of the violation, and what have you done to remediate since then? And then reputational harm obviously is a big factor for a lot of companies, and the financial impacts, right? That can arise not just with your contracts, costs, quality, schedule, but with the enforcement actions. There's steep penalties, there's treble damages. The dollars can really add up quickly. And really impact your bottom line. And so let's end on the last slide. So I'm pulling the lens back out even further. And this just goes into, I think now with the EOs, and then who knows what else is coming, right? It's just a good time to dust off your ethics and compliance programs, your internal protocols. These on the screen are what I sort of preach as your sort of 12 pillars that you should be thinking about when you're looking at, how are you implementing compliance within your company. And so it runs the gamut from company values. These are sort of the catchphrases that describe your organizational culture, to your program structure, like I mentioned, who's in charge, tone from the leadership commitment. Are the leaders walking the talk? Do you have the proper tone from the top? And a lot of this too gets at mitigating the key TAM risk, right? I mean, you don't, especially at big companies, you got a lot of folks in your workforce, and you may be people looking for perceived violations in the current environment. And there's monetary incentives out there to bring one of these actions. So you want to have these internal protocols set up as much as possible to build against that. Risk assessments, policies and procedures we talked about, look at your code of ethics, look at your training protocols, your communications platforms, and then, doing program audits, right? Don't just have a paper program, set it up, and then never look at it again, right? Make sure you're implementing it properly. Reporting mechanisms, these are hotlines. Are people actually using the hotline? Is that phone ringing? Is that advertised? One thing to look for is if your phone is not ringing, that may be a problem, because people may either not know there's a way to report, or they may fear reporting out of retaliation. And so you want to think about that. Typically, if the phone's ringing a lot, you've got a good, robust program going on. Investigations, disclosures, Kristen Ellen touched on that, and then discipline and incentives to kind of round out, what you should be at least thinking about at some level within the resources that you have internally. And I think,
Okay.
Ellen, back to you, or Annette, back to you.
Yeah. So that, there's a lot that's out there, right? As my colleagues have been sharing, there's a lot outside of the direct diversity, equity, inclusion programs themselves, right? There's a lot of implications as we think through them. So today was part one of a series that we are launching, and we do have, just up on the screen, invite you to these other series that will be coming up. Stay tuned for additional announcements. One of the things that everyone is grappling with is what are the contours of what might be an illegal DEI program? How might that be defined? So we are going to be focusing on that. We'll also be having a webinar on navigating supplier diversity issues, cause-based investment strategies. That's a newer one that's coming across many of our desks these days, community-based giving, and other questions. And these are all based on common questions that we're getting from clients. On the next slide, you'll see our CLE code. Kate mentioned that in the beginning of our slide, so I'm going to read the code to you. It is SS, as in Seyfarth, Shaw, 3722. That number again is S as in Seyfarth Shaw 3722. We will be sharing the slides. Be on the lookout for additional webinar presentations in this series. We thank you so much for joining us for this presentation. Thank you.